Have you ever forgotten you were married or how many children you had? Did you remember to update your estate planning after the birth of child number 3, or perhaps more pressingly, after your divorce or remarriage? Believe it or not, a massive cause for fights in the estate planning world come down to documents not reflecting the current family tree. Next thing you know, we're in a fight over forgotten spouses or children, either accidentally forgotten or intentionally omitted. So, let's talk about that. But first, thank you so much for watching. If you find this video helpful, please hit the like button, and if you want to see more, please subscribe and ring the bell, or drop a comment below. Picture this: you're basking in the California sunshine, and then boom, the lights go out. Your beloved, expecting to inherit your earthly riches, discovers they're actually the ghost, at least when it comes to your will or trust. In California, if you inadvertently leave your spouse out of your will or trust, they transform into an omitted spouse, like an overlooked character in a thriller novel. But instead of just fading into the background, they're entitled to a fair share of your worldly estate. And what does this estate consist of, you ask? Well, it's sliced into community, quasi-community, and separate property. Community property is everything you and your spouse acquired during the marriage, except for gifts or inheritances. Quasi-community property is a bit like community property's distant cousin. It includes assets acquired while living in another state that would have been considered community property if you were living in California at the time it was acquired. Separate property is anything you owned before the marriage or that you received as a gift or inheritance during the marriage. And your omitted spouse can lay claim to half of each of these types of property according to California's rulebook, that being the California Probate Code, specifically sections 21610 through 12. Keep in mind that with separate property, there are some situation-specific cases where an omitted spouse may receive less, but still get one half the community and quasi-community property. But what if your omission was intentional? Section 21611 of the Probate Code has the bases covered. If it's clear you meant to exclude your spouse, or they waived their inheritance rights, or you left them something outside of the will, such as an insurance payout or retirement account, plot twist, they might not qualify as an omitted spouse. Prenuptial agreements can also play a key role. They're like a third act revelation that can alter an entire narrative. A prenup can prove that the spouse knowingly agreed to be excluded from the will or trust. It's essentially the ultimate, I signed up for this pact. Now, what of the forgotten child? Well, if it's a child that's left out of a will or trust, they can also inherit a share of your estate. Their slice, however, depends on whether you left clear intention to exclude them, left most of your estate to the other parent, or provided for them, that child, outside of the estate. According to California Probate Code, section 21620, if a decedent fails to provide in their will or trust for a child born or adopted after the execution of all those documents, the omitted child shall receive a share of the decedent's estate equal to what that child would have received if the parent had died without a will or trust, essentially intestate succession. However, an omitted child does not receive a share in the following circumstances, though. Number 1, if it appears from the will or trust the omission was intentional. Number 2, the decedent had one or more children and handed down substantially all of their estate to the other parent of the omitted child. Or number 3, the decedent provided for the child by transfer outside of the estate with the intent of that transfer being in lieu of an inheritance in a will or trust. An additional provision, Probate Code section 21622, specifies that an omitted child may receive property or assets under the will or trust if it can be demonstrated the decedent did not provide for the child because they believe the child was either dead or they were just unaware of the child's birth, as in the long-lost love child. Always remember, putting things down in writing when estate planning is key, as it ensures the planner's wishes are followed and their intent is respected. However, problems arise where these documents are either not updated with the change in family dynamics or not reflective of the situation when they are initially drafted. This is the primary reason for seeking legal counsel, ensuring everything is done right from the get-go and considering any potential scenarios. Don't forget to hit that like button if you found this video helpful or entertaining, and subscribe for more videos on law, finances, and estate planning. If you've got any questions or think you've seen a legal ghost lurking in your paperwork, drop a comment below.